Thank you all for coming today. I'm Charlie Sauer. I'm president of Entrepreneurs for Growth and co-director of one of our projects, the Inventors Project. We're proud to co-host this event today with the Center for the Protection of Intellectual Property. When they called me up to discuss the event, which is trying to make the business case for patents, which is somewhat different than the legal case for patents than we hear about in this debate. I jumped on it and I was excited about the event. As intellectual property moves this year, and it looks like it's going to move again fast, it's important to remember how the small businesses and the small innovators and the innovation economy are affected. And so that's why we have our panelists here today. We have Louis Foreman. He is a serial entrepreneur. He has 12 patents. The most important thing that Louis does, in my mind, he's chairman of a few things. He was a former chair of the Public Patent Advisory Committee, but he's chairman of Edison Nation. And through that, he's a mentor to lots of inventors across the country and is active every day advising them on how to build their companies, how to build their ideas, and how to make our world a better place. We have Valerie Gatos, who I'm proud to say is a co-founder of Entrepreneurs for Growth with me, but as her day job, she is the chairman of Capital Growth. She's an advisor to small businesses, and if you haven't had the chance to visit, she's also the co-founder or founder of a group called the Angel Venture Forum. They have an event in DC every year where they bring inventors and startups and entrepreneurs in from the area along with investors, and it's kind of like a real-life Shark Tank, except for the businesses have spent a year working through her programs, so they're ready to go. They've built their businesses, and the investors are there ready to invest. She has an impressive investment ratio coming out of that makes the investment ratio coming out of the Shark Tank look like a TV show. Then we have Adam Mossoff. He's a professor at George Mason University, runs the Center for Protection of Intellectual Property, and is also one of my favorite academics on this issue. He's written extensively on patents. He speaks around the country about patents and has frequently testified in front of Congress. Today I want to start off with Louis, and then Valerie, and then Adam to make some quick introductory remarks. I have a couple of questions, but then we want to open it up to you all. So as they're talking, please start thinking about your questions now. Louis?
Great. Well, thank you, Charlie, and I'm honored to be here. When Charlie asked me to come and address this group, the first thing I thought, what can I add to this discussion? And Charlie said, well, you're an entrepreneur, you're an inventor, just tell your story. And so my story is quite simple. I'm a serial entrepreneur. I started my first business when I was in college. I realized that there was opportunity to create something, and the businesses that I've created over the years have all been based on intellectual property. Now, of course, I didn't think about it in those terms back then, that these are patents and there's all these issues related to patents. What I looked at was I needed an incentive. I needed some reason to assume risk. And I saw intellectual property and patents as a reason to justify not taking a real job, raising money from friends and family, starting a company, hiring people, growing a company, starting more companies, and hiring more people. And so I've always looked at intellectual property or patents as kind of the reason or the justification to assume risk. And that's what entrepreneurs do. We assume risk for the sake of reward. But if there's not some underlying asset there that we can tie the decision to, then why would I ever do it? I would just get a job like everybody else, and I would do what everyone else does. And so my story began in college, starting my first business. I've started over 9 companies. I teach entrepreneurship. I try to inspire people to create companies. But I also recognize that there's a lot of value in patents and invention. As Charlie mentioned, I have 12 patents, but my company, we have over 700. What we do at the company that I started, which is called Inventors, it's a product design firm, is we're hired by large companies to invent. We design, we engineer, we prototype things, but we don't make anything. We license our inventions to those companies, and the way I pay my staff is through the royalties that we extract for the creation of those products. So I guess in many cases you could call us a patent troll because we don't manufacture anything. But the reality is that that's how we create jobs, and that's how we create opportunities, is by creating something from nothing. And we file patents around those ideas, and we get paid through the form of royalties. We also created a TV show because we thought that the country needed to be inspired and educated on the process of intellectual property. And so in 2007, we partnered with PBS to produce a TV show called Everyday Edisons, pre-Shark Tank. We don't throw people off an island. We don't humiliate people. I guess we're kind of the nice, friendly PBS version of Shark Tank. But the reality is that everyone out there has a great idea. Most people don't follow through with those ideas because they don't have the time or the resources. But the only way you can extract value from an idea is you've got to protect that idea. And so we each season look at tens of thousands of ideas. Last season we had 35,000 inventors submit their ideas to us for the TV show. We choose 10 that we like, we develop them, we file patents, and we license those products to companies, and we make dreams come true. Again, that would qualify or be interpreted as being a troll by the very definition that's being floated around the Hill. And so we've been pulled into this discussion because we feel like the independent inventor is really the collateral damage here. This discussion of making it harder to enforce patents is going to have a profound impact on independent inventors and their ability to extract value from their ideas. It really comes down to that simple equation, the risk and reward. And if there's no value associated with going out there and creating and making the financial investment or the time investment to create something from nothing, people aren't going to do it.
Valerie?
So I think he captured that correctly, reason to assume risk. Now, I'm on this side of the table. I have started companies myself, and I've sold and purchased companies, and I'm now on the side where I invest in companies. And so if I'm going to invest in his company, I need to have a reason to take the risk as well. Well, with a startup, what do they have? They don't have customers yet. They don't have assets. They don't have prototypes. But what they do have is intellectual property. So when I put my dollars into a company, I need something that says they have something, so that if there's a garage sale tomorrow, I want to be able to say, you know what, you didn't make a go of that technology, but if all else fails, I can at least sell it at the garage sale, so to speak. I mean, that's worst case scenario. Otherwise, there's no collateral. Your bank won't lend to you unless you have collateral. Well, I'm not going to invest in something that I don't have collateral of some sort. And oftentimes intellectual property is the only thing that a company has. Ironically, one of the other projects that I work on is we do tech transfer. Sometimes when a company comes to me and they're looking to say, look, I need $500,000 to create this software or create this technology. And oftentimes we say, well, wait a minute, this is already created in our agencies. NSA, NIH, Edgewood Biological Chemical area, it's Aberdeen Proving Grounds, the Army. We also have Johns Hopkins, the educational institutions, the Applied Physics Lab. We're looking at these technologies in these agencies, and the first thing they say to us is, when we want to license this from them, they're not going to give it to us. I mean, would I love them to give it to us? Yeah, you bet. But you know what? Their response is, but the government has put so much time and effort and research into this. So I find it really ironic that we're eroding laws that actually undermine our own system of the money of your tax dollars going into creating these technologies. So, is it fair to have just the government protect their technologies? Well, you know what? If I license it from them and I create a company out of it and then I put my technology on top, so are we saying that, only the government technology should be protected? Well, no. If I'm going to create something that's creating on top of technology that exists, I should be able to protect my stuff too. Otherwise, I'm not going to take a risk and I'm not going to license it from the government. So I just find it absolutely ironic that we're eroding the very basis of of what has made this nation such a great innovator in the world.
Charlie, I think it was very smart of you to have the academic heads in the clouds guy go last. And the reason why I think that is because the process here of our speaking order reflects exactly what we're trying to achieve with the Center for Protection of Intellectual Property, which I co-founded with Mark Schultz 2 years ago. And I thank you, Charlie, for saying I run it, but I actually don't. That's Matt Barbalon who's here. Because we founded CPIP to create more ground-up, fact-based research. So you should hear the facts, and academics must learn the facts before starting propounding theories or explanations, or worse, making up data about what is really happening in the world. And it was really interesting for me, so I got out of the ivory tower and founding CPIP and started talking with real-world innovators like Valerie and Lewis and others. And what I learned, and what I began to learn, was that what I understood in theory is the unique American approach to securing property rights and innovation, and what that really meant for innovators, because innovation is an inherently risky endeavor. And we often think of patent system as promoting invention, but what we don't often realize, and this is what you're hearing from both Lewis and from Valerie, is that invention in the lab is not the same thing as the product that you actually end up holding in your hand in the real world. And that if you're talking about innovation, which is what the patent system is about, it's about bridging that gap. And that's what the patent system makes possible. By taking people who are inventors, who are the geeks. We're not the business persons. We're the people who spend time in the lab or in some garage, coming up with the next great thing that's going to challenge a current business paradigm or technological paradigm. And we then lack the skills to understand how to implement that, create the production chain, create the distribution chain, and to face the potential risk that that could still be a failure in the long run. And so when we talk about the unique American approach to property rights and innovation, which is what the Americans took, that was the approach that Americans took in the 1790s. What we made possible was to have a professional class of innovators who, like Thomas Edison of Edison Nation, like Charles Goodyear of rubber, like Nikola Tesla, or another great electrical innovator, and many, many others, who none of them ever manufactured. They simply took advantage of the division of labor, were able to license and transfer their rights, their property rights, to the manufacturers, to the commercial experts that would then bring their inventions into the marketplace and make it possible for all of us to prosper. And I think that's very important for us to always keep in mind, that when we are talking about the patent system and making changes to the patent system, what we are doing is making changes to a system that is at root about securing property rights and innovation, which makes it possible for innovators and inventors to come up with their ideas, to get the funding necessary, to then embrace the full panoply of commercial risk and contracts and institutions that are necessary to ultimately take something from the lab. So for instance, the iPhone, which was invented in the lab, and it was 5 years before it was actually deployed in the marketplace. And what do you think it was just that Steve Jobs decided to sit on this great invention for 5 years? It was no. I mean, it was because there had to be extensive technological and, more importantly, commercial innovation that followed. He had to get the distribution chain set up, the supply chain set up, retailers, wholesalers, figure out how to pitch it, how to create it, create the ancillary commercial mechanisms that go around it. And so this is very, very important. So when we're talking about changing the rules by which people can litigate their patents, which sounds superficially like it's a good thing, like we want to get rid of abusive litigants, what we're talking about is not a type of tort reform. And that's very important. What we're talking about is weakening property rights. We're weakening the foundation of the innovation economy, that the very property rights that serve the basis for innovation and commercial activities in other areas are the very same type of property rights that are driving all of the great innovation that we experience today. From iPhones, going back to Edison with his great inventions in the record player and electrical distribution systems, Nikola Tesla, the same, Charles Goodyear, rubber, and that's what we need to continue to secure.
Can I just put an exclamation point on that?
Yes, please.
Eroding property rights. Think about that. No longer will we be able to own stuff that is ours. I mean, that is really the foundation of this nation. And all of a sudden, if you eliminate all those property rights and everything is owned collectively, what does that sound like? I mean, That sounds like other failed nations, doesn't it? So, exclamation point on that.
Thank you.
All right, let me build off what Adam said, and we're going to come back. I want to go through Lewis and Valerie and talk through kind of what Adam was talking about and how intellectual property actually works through a business, and then I want to apply that to the legislation that we saw last year and that we're looking to see this year. Lewis, if you could kind of talk about maybe at what point intellectual property comes into building a business, or when you're talking to, when you're mentoring a business and working with businesses, and in your own history.
Well, I think like Valerie mentioned, it is the underlying asset that you're leveraging to build a business. And so if there isn't some form of protection to prevent others from making, using, or selling what you've created, there's very little incentive to go out there and risk your time, your money, the money of your friends and family, or even to go out and try to raise money from VC or private equity or angel investors. So it becomes kind of the core essence or element of a business if you're going to start it. You know, to be successful today, because almost everything that we need already exists, you need to have something that's different. You need to have something that's unique, that's different than the competition. And quite often, it's the patent that differentiates that product or service from what the competition is selling. And so having this period of exclusivity where others can't make, use, or sell what you've created is the reason to make that huge bet to go out there, maybe quit your job, or maybe risk your family's, financial resources to go out and start a company. I can't imagine an entrepreneur trying to start a business without having some core asset that is the basis or foundation of that business.
And what level of, when you're building that, you know that it's important, you know that you need it to fight for the investors and to differentiate your product. Where does the litigation, or where does a courtroom fit into that outlook, or when you're looking at building an IP portfolio?
Well, I can tell you as an independent inventor, litigation is the last resort, right? I mean, it's not something that you go around and you threaten people with because it's so expensive. But it is something that is there if you need it. And it's what keeps people honest, right? I mean, I don't always drive, the speed limit, but knowing that you can get a ticket and go to court for it is what, keeps you from going too fast all the time. And so there needs to be some sort of laws in place that make sure that you keep the honest people honest, and you keep the people who are going to cause harm, keep them away. We find in our business, we get a lot of infringers. The products that we develop, the consumer products that we license, there's, imitation's the sincerest form of flattery. And, all you have to do is go on a website, Alibaba, and you'll find hundreds of knockoffs of the products that we have filed patents on and received patents on. We clearly have to let those companies know that they're selling an infringing product. Do we threaten litigation? No, but we let them know that we've got a patent on what they're trying to sell. So I guess we're sending abusive demand letters in that particular case. But we have to let people know that we're trying to protect our property rights, not only for us, but also for the inventors that we represent.
Valerie, I guess that it's kind of moving the question through to you. You talked a little bit about it, about why intellectual property is important, but can you talk about also when you're doing, I know you do due diligence on companies, how you look at intellectual property and before making that final decision?
So intellectual property is one piece of the equation, clearly. So it's not the only thing that we invest in, but it is oftentimes the deciding factor. So I've been on panels with other folks who said, well, IP, it's not really that big of a deal. And the question I threw back was, have you ever invested in a company that didn't have IP? He said, well, no, but okay, that answers it. Because while it's not the only thing that we invest in, because there are people that come up and show me hey, look, I invented this. But exactly what Lewis said is that, these are guys who are good at inventing things, but do you have the other pieces of the business that can sell it? Do you have the distribution channel? And sometimes, we can get the initial customers, but we don't have the big distribution channel. That's where we have the opportunity to take a product, prove that there is a market for it, have some sales within our realm of sales, but we don't have the big reach like some of the bigger companies. That's who we sell to. So a perfect example of that is that we had an inventor who came to us as a batch of investors who was trying to solve the problem of a repetitive motion disorder, carpal tunnel, and he was a researcher in the University of Delaware. And so we looked at his technology, and he wanted to sell it to insurance companies. People do big data input, and so he showed us his product, and he had a touchpad that looked like this that you can snap in so that you don't have to press a button. You can just nice and smooth. And then he had the gesture pad. So this hooked USB to your computer. It's called Fingerworks, and you could move it around. You can cut, paste. What's that sound like? Cut, paste. Well, we invested a little less than $1 million into the company, turned around, and we sold it to Apple in 2004. Okay, so this guy was developing this for 6-7 years. In fact, he was living out of his car, by the way, as a researcher. And so we invested in 2004. 5, 6, 7 is when the iPad came out, the iPhone with the touch screen. So this is really the precursor to the iPad. So people sit there and they'll say, well, Apple is the greatest innovator in the world. No, Apple's the greatest aggregator, okay? Because they had the market. I didn't have their reach. And this was only a piece of the equation. So if we could not have that license, or we couldn't license this to Apple, and Apple said, fine, we'll just go ahead and take it, and great, thanks for inventing it, we'll duplicate it. And so that's the value, and so we did very well financially on that. People say, well, we sold too early. No, we didn't, because there were probably about 10 other people inventing this, and that's okay. So in a way, Apple got it for cheap because there were people inventing it all over the place, and we knew we had to sell it quickly before someone else invented it. So not only does that whole, not having to file, and I know that was a big complaint that it's first to invent. I know we've changed that, but I think it keeps everybody on their toes when they know that they're inventing out there, and it actually does keep the price low for Apple and for other. So, but that's a perfect example of a product that, if we weren't able to invest in those rights, then it would never have been developed for Apple.
I think that was explaining kind of what you went through, and but we have a general idea about what's probably going to be introduced this year. It sounds like it's going to be something almost exactly like what was passed through the House last year. I will note that the one thing not in that bill was the full funding of USPTO, which is something that I think everybody in this debate believes is valuable and could only help provide better intellectual property. But can you talk for a second, Adam, about how the changes will affect what Lewis and Valerie discussed?
Yes, because a lot of people don't realize that, because it takes a little bit of connecting the dots, and so they hear the anecdotes about abusive litigation by some people, and of course there's always going to be bad actors in every system. You can hear about abusive litigation in contract law. You can read cases about abusive litigation in many other areas of the law. So you're always going to have a couple, some bad actors. And so what you hear is that, well, we need to respond to those bad actors, and so we need to, for instance, make it harder to sue. So they want to raise the pleading requirements. They want to make it harder to do discovery. They want to impose a presumption for mandatory fee shifting if you lose your case, if you're the patent owner and you sue. They want to have mandatory joinder of anyone who may have an interest in the patent, to be brought in, who could then be susceptible, for instance, to the fee shifting, have to pay the fees. Now, all of this sounds in the abstract like very reasonable. What could be wrong with that? Hey, you bring a frivolous lawsuit, you should have to pay, and things of that sort. But what people don't realize is that what this creates are burdens to enforcing your property rights against infringers, right? It makes it harder, more costly to enforce property rights against people who are trespassing upon your legitimate property right. And when you add up all of the changes, it's a tremendous amount of burden. especially for individual inventors who are living out of their cars, or undercapitalized small firms or inventors who don't have the ability to say, yeah, I want to sue, say, Google. And they're sitting on a multi-billion-dollar war chest, and they're saying, well, we're just going to litigate you into the ground. And we'll eventually win, and then you'll be on the hook for all of our attorney's fees, even though there's a plausible argument that Google perhaps has taken your invention. So what do you do in that context? You're stuck. I mean, what people don't realize is that litigation is the backstop that all property rights owners have to enforcing their property rights as property rights and entering into agreements with people. So for you, those of you who own homes, when you invite someone into your home, it's under the understood premise that if I decide to kick you out, you will leave. And if you don't leave, I can call the cops and bring a trespass action against you. If the person who comes in your house thinks, yeah, but before you call the cops, you have to file a 15-page affidavit as to what were the conditions under which you brought me in, and by the way, you have to post a bond of $10,000 in case I'm potentially injured, and by the way, I can bring in joinder of your ex-wife who could be responsible for my counter-tort lawsuit and things of that sort. All of a sudden now, you no longer have the ability to kick people off of your property.
Sounds like the landlord-tenant laws that are currently in place.
And trespassers know that. And here you have a system where there is tremendous economic incentives for established companies who are being challenged by upstart, disruptive innovators to want to incorporate and take innovation. And now it's easier for them to do that because they know there's greater costs being imposed upon the other people.
So let me take that one step further than this. So if let's say, these changes were made, what would happen with this piece of technology is, and I don't mean to pick on Apple, but I will. So Apple can turn around and say, you know what, we want that technology. So they can then slap lawsuits on me to drive me underground, and I know, oh my God, I got to sell this to them, before I go bankrupt, and then I will have nothing to sell. So it actually works the reverse as well, is that it puts more burdens on me. I can't even afford to then fight someone like Google or Apple, who just puts a frivolous lawsuit on me as a small company. So what it does is that it actually is going to force me as the investor or the inventor to fight harder fights in a fight that's already really hard to begin with. So now what I do is extremely risky. This now just multiplies and adds more risk on what I do. And I find that very problematic.
Well, actually, let me just interject, Charlie. I think the bigger problem is there'd be no incentive for the inventor to create that product if they couldn't protect it and they couldn't license the product or raise capital because the patents don't really have any value. Why would they ever venture into that in the first place? So I think you kind of rob society of that discovery.
And I understand the narrative that was developed from last year was, the trial lawyers got involved, and that's what brought to an end. But that was the narrative that was created by the people who have been pushing for this legislation, who have put, as recently identified by IM Magazine, tens of millions of dollars into lobbying money to make this legislation possible. The reality is that the Senate started listening to these individuals and even universities who are often included in every one of the anti-troll studies. They are included as trolls, universities, because they don't manufacture. They solely license their inventions. And if a university licenses its invention and that invention is now, that patented innovation is now involved in a lawsuit, the university as the licensor has an interest in that patent, and under the mandatory joinder rules would be required to now be part of the litigation, and then would be on the hook potentially for the presumption that attorney's fees have to be shifted and paid for if that occurs, which could run in the millions of dollars. And universities don't have that type of money.
Universities got some exemptions.
They started to get some exemptions, but the problem is that.
But again, how fair is that? Even if
exactly.
they got some,
So,
how fair is that to me?
Right. I mean, then you have what you have is classic special interest legislation, where the people who have enough of a clout can get themselves carved out of the problematic aspects of the legislation. And what you're creating within a patent system that was supposed to be a democratic patent system, provide the same property rights to everyone, the same similar rights to all the different types of innovators that exist. You've now created the classic regulatory type regime with special interest lobbying on both sides, and that is the death of innovation, not the birth of innovation. That's what the United States got away from when we created a property rights system, as opposed to the special privilege-based, special interest-based system that they had in England and in other countries when we had our revolution.
When we talk about innovation, when we talk about business growth coming from the small businesses, it's really the innovators here that are creating that growth. It's the my members. It's the 2 to 3 guys in a garage that are looking to be 2 to 500 in the next year or two, or probably be out of business. And that's one of the aspects that Lewis started hitting on, and Adam hit on, and Valerie hit on. The risk for these businesses is high. If we pass these laws, the risk for the innovators like the universities is higher, which means we reduce innovation, which means we reduce investment, which means we reduce job growth. And that's just not something that we want to see. And so it's, I think that's a good place for us to start taking some questions.
We keep hearing the argument, and to me it's so counterintuitive, but we keep hearing the argument from Engine and from CEA, which now claims to have 500 startups as members, that unless we reform this whole system, it's going to hurt startups and kill innovation. And people have bought that argument. I mean, I go up the hill and I get that argument repeated back to me, and I try to say, that's wrong. Think about it. The Shark Tank analogy. You walk into Shark Tank, what's the first question? Do you have a patent?
Yeah,
it's not,
exactly.
are you going to be sued by a patent troll in a couple of years? So, again, how do we make it clear when we get that argument back that it is so counterintuitive?
It is counterintuitive, right? I mean, it would be as simple as, you own a piece of property and you want to build a house, but if you couldn't get clear title to that property, would you ever start hiring a contractor to break ground and put up a structure if someone could come in and say, no, actually, I own that land? And so how would anyone ever justify the financial risk of starting a business if the underlying asset underneath it couldn't be protected and that you couldn't prevent others from competing with you? I mean, it just doesn't make any sense. And it's interesting, because there is this California belief that, maybe patents aren't a good thing and that they stifle innovation. But when you talk with those individuals,
Yeah,
okay,
right.
thank you for the clarification. In the South, we understand it perfectly well. But when I've spoken with some people who are in kind of that industry, and they kind of toe the company line that patents stifle innovation, when you start to explain the issue, they very quickly realize that they're wrong. I think they've just been fed this information. They've heard it enough that they believe that it's actually true, and that's the problem. It kind of goes back to during the AIA days when everyone was talking about this is bad, this is bad. People just started to believe it as truth. And once they realized that the facts were against them.
Well, I think there's a subset of folks in the software industry, and frankly, I think this builds our case that they need to fund the patent office more. Is that some patents are actually pointless because it takes the patent office so darn long to pass them. Software, for example, and that's why you get the folks from Northern California saying, well, patents stifle innovation. Well, because it takes, you've got to wait so long to even have your patent, because I know I'll say to a company, well, did you get a patent? Well, we filed a patent. Okay, well, you know what, by the time you get a patent on that software, yeah, you're right. It may already be obsolete because the patent office doesn't move very quickly. So in those instances, I would absolutely agree that the patent is kind of useless, and that's why we say, you know what, forget the patent office, let's try to create, while you file your patent, so let's believe that eventually they're going to give you a patent. So that's a risk we take. But if we do our homework, we will say, you know what, I believe that they will give you that patent. So in the meantime, let's hustle ahead and get the market and, get customers, et cetera. But still, the root is back down to the patent. So that's where I think that nuance is, where you've got some software folks saying that, oh, they're not important. Well, yes and no. But they're investors. I can tell you from the investor standpoint, their investors still would not invest in them if there wasn't even a patent filed.
and your question was directed to them, but in response to your question about how do you respond to some of these claims, it's one thing to say, oh, we don't need patents, but when you, but as I think as Valerie and Liz are pointing out, when you actually talk to the actual venture capitalists and you actually talk to the actual innovators and inventors, they always rely on patents, and that was confirmed in a very well regarded study that was done out of Berkeley, where they interviewed venture capitalists in all the sectors of the innovation industries, in biotech and in software, and one of the common themes that they kept hearing was, we look to patents to make our investment decisions. So I understand that there's this kind of rhetoric that's been framed around among software programmers who historically, going back to the 1960s, were opposed to copyright protection for software. And some of it is from companies that don't rely upon patents for their business models. They rely upon other types of intellectual property rights or other types of property rights, like trademark perhaps, or trade secret. But I think it's important to break through that rhetoric and to just identify the facts. Just as a basic fact that you probably don't know is that Sergey Brin and Larry Page got a patent on their PageRank search algorithm. A lot of people don't know that. Why don't they know that? Because Google doesn't talk about it. In fact, if you look at Google's official history page of their company, you will not see a single mention of that fact. Then not only did they get a patent on it, it's mentioned in their request for VC funding. They were filing for a patent on this. They don't talk about that. Why? Because they have developed a business model now that no longer requires patents. It requires other types of property rights. But then but the whole point of the patent system and trademark system and others is to provide for the myriad business models that can exist and should exist. And we shouldn't be allowing the companies that don't rely upon patent innovation to dictate what the patent system will be, to make it impossible for the inventors and the innovators who do rely upon patents to make their business models possible.
In addition to that, you're in members' offices here, so you get conversations from people who represent trade associations. So you sometimes think, well, they are the voice of that industry. The reality is that that technology and all these associations are very vertical. That's the problem. So you have a trade association says to you, we, all software developers, or all, laser manufacturers, all of us support or oppose this. But that's just the trade association telling you what the aggregate in the group is. But the reality is that who runs and who funds those groups? The bigger guys who put money in. So when I ran a technology council, I've run other trade associations, the thing is that you have to look at the members and you have to see what percentage, and they'll never tell you that. I mean, that's just the truth. So when a trade association tell you that everybody in our industry is opposed to this, say, I want a list of your members, and you guys pick up your phone and call the members that you've never even heard of that name of that company and ask them what they think. And I betcha they will not be towing the same line as the trade association that they are a member of. And simply for the fact is that they are a member of that association, not because they necessarily believe in the views that the association is putting forth, but they want to have relationships with the Google and the Apple because we want to be able to sell our product to that. So we as a small business are sometimes put in conflict because we don't want to necessarily say anything bad about that, or we recognize that the industry association represents us in many other ways. So if you really want to be a responsible member, staff member, pick up the phone, get a list of the trade association who's telling you what their opinion is officially, and just talk to some of the members you've never even heard of.
The patent system, of course, as you know, was created by our founders to protect the innovation of all Americans, before corporations and all that. One of the things I've noticed is since I started practicing in the early 90s is that the small inventor community has almost zero voice in any Congress or any, the entire narrative is governed by the special interests, especially with the AIA. But the small inventor community, in my view, needs to get back there and make their, make their voices known. Because until the value of intellectual property increased in the 2000s and everything, the small inventor community come in at the last minute and derail any legislation. Now, we've gotten complacent and nothing. Millions of dollars you can't make a dent into it.
I don't know whether it's complacency.
Well, it's complacency in the sense of during the 2003 to 2011, the titans, tech and biotech were battling it out, and the small inventor community just backed out and let them fight it out. So the infrastructure disappeared. So now we have to bring the infrastructure back.
But you understand the obstacles that independent
Of course.
vendors face, right? I mean, we're not funded, we're not organized, and we have other things to be doing, like inventing and trying to create
Surviving,
businesses and
yeah.
surviving. And so we don't have the value or the
Full-time
advantage
lobbyists.
there. You know,
Exactly.
Edison Nation, our community is hundreds of thousands of independent inventors. We publish Inventors Digest magazine, which has been around for 32 years. You know, it's the only publication for the inventor community. But we still represent just a small fraction of the overall independent inventor community, because most independent inventors don't consider themselves necessarily independent inventors. They're just people who come up with great ideas. But they are going to be the collateral
They
damage
have to
in this
become
situation.
They have to become advocates for the system. It's as simple as that.
Well, that's why we're doing this.
Thank you for your question. Yes.
example, I heard there are fewer people filing lawsuits now, that the Supreme Court had some decisions that would give more flexibility to judges. The Federal Trade Commission is now starting to go after. Can you speak to how the marketplace is almost self-correcting on something?
Yes, thank you. So I'll just take a quick moment to talk about these issues, because I think this is relevant for Congress in considering whether to make further revisions to the patent system after making massive revisions in 2011 with the American Invents Act. Congress is not the only institution that governs how the patent system is going to be applied to innovators and also to potential infringers or licensees. And a lot of the complaints which are litigation-based type complaints, that is within the domain of the judiciary, of the separation of powers of our government. And so unsurprisingly, the courts responded to the complaints from the bar and from the interested parties, relevant interested parties. And so in the past several years, the Supreme Court actually has been hearing more Supreme Court cases in the past several years than they have in about 100 years. They haven't heard as many, in the past 2 or 3 years, they hadn't heard as many Supreme Court cases as they heard in the past couple of years since the late 19th century. And as a result of that, for instance, you had a substantial lowering of the bar of the ability for courts to award attorney's fees to abusive litigants. You've had a tightening up of the patentability requirements for describing your invention, what types of inventions can be granted, whether in the computer implemented technologies area, what's colloquially known as software, in the biotech space, and many, many, many other revisions. The regulatory agencies themselves have been going after the deceptive and fraudulent practices of the identified bad actors that exist, that have been identified. And in fact, the FTC recently reached a settlement with the notorious scanner patent owner in their carpet bombing of demand letters. And so and also the Judicial Council has responded by actually proposing that you eliminate what's known as Form 18 in patent litigation, which is the notorious form that has lowered the pleading standards for how you could bring a patent lawsuit. All of this is within the domain of the with classic traditional judicial functions to control their dockets and to control bad behavior of litigants and to apply the patent laws as they exist. And what you're seeing appropriately as a result of all of this is, as of this past October, it was reported that there was a 40% drop in patent litigation over the prior year rate. 40% drop. So when you hear Senator Cornyn or Representative Goodlatte or other representatives talk about this, there's been this massive explosion of patent litigation. Actually, it's corrected. And it's corrected largely in response to the changes there. You would expect those changes to take place, which is in the judiciary, not in Congress, or not even in particular in the executive as such.
There's also has been a drop in the amount of angel investing done from 2013 to 2014. Now, I don't know, there's any actual cause and effect that could be directly correlated, but I think some of it is that, we're looking at from the angel investment community being bombarded by so many things, including capital gains tax. Remember, when we invest in a company, that money's in. So if the capital gains tax changes, it's not like I can turn around and say, well, it's going to change next month, so therefore I'm going to take my money out of the market and take my gains now before the rate changes. No, it's in a startup company. They don't have any money to pay me back until we actually sell the company. That could actually force us to sell the company if the shareholders say, you know what, we got to dump this company before I get taxed to death on this and make no money. So, those are the things that are all affecting us from the investment community. Again, I don't know if there's been any ties, from 2013 to 2014, but I would say that it all adds up collectively. And that's the challenge, is that, you ask us, well, can you pinpoint? Well, you can't pinpoint. And that's the danger of doing so many little changes all over the place, is that how do you know which is going to have that direct effect? I mean, it's kind of like a doctor tells you, you change one medication. If you're on 6 medications, doctor tells you change one medication at a time so that they can pinpoint what the cause is. I mean, to me, that alone is reason not to touch and do any more reforms of the patent laws, is because they've already changed so much. Let's figure out where those changes are affecting, for the better or for worse.
And do you think, from an entrepreneur or investment standpoint, are there any other tweaks or modifications of the patent system that are warranted?
Well, I think that's a good legitimate question. Full funding of the patent office, I think, is a good start. And what must accompany that, of course, is the end-to-fee diversion, where money is taken from the patent office because patent applicants pay fees to get their patents. And it was promised in the American Invents Act. In fact, that was one of the key compromises in the American Invents Act that brought a lot of people who originally opposed it on board, where they said, great, this end fee diversion, and it ended up being a completely false promise, because fee diversion came immediately back. And so also, you can do, Valerie makes a very good point, right? That there's an extensive amount of uncertainty in the patent system from all of the changes that I described in response to that. And not to mention the ongoing uncertainty from the American Invents Act. The American Invents Act hasn't been even fully implemented. We still don't have yet full data on all of the post-grant review and all of these other review programs at the patent office, and some of the new rules on how many litigants you can file cases against and things of that sort. And so the one universal is that investors and inventors need certainty in their property rights. And if you don't have that, you're not going to have innovation.
I know a minor tweak. They can actually have the price to file a patent actually go down for startup companies, and not enable the bigger companies to do in bulk, because when the larger companies do in bulk, they file hundreds and hundreds of patents, and what it comes down to is they're like the Walmart version, because they can actually file them in bulk, and it's per patent, it's just so tiny. For us, it just kills us. I mean, it's like going to a check cashing business. I mean, it totally obliterates the person's check. That's where we are as a startup company, because when we go and file a patent, it can cost $50,000, $100,000 for just a minor patent. But for that same exact patent that is bulked with, the bigger companies, that costs them hardly anything, and they're the ones that actually can afford more.
But in all fairness, that's the legal fees, not the patent
It's
office
legal
charging
fees.
it. I mean, independent inventors get the best deal in the house at the patent office.
Yeah,
I mean,
the venture
75%
status, yeah.
off, list price if you're a micro entity.
Yeah.
But fee diversion is definitely a problem. Uncertainty is a huge problem. And uncertainty from capital gains, uncertainty from litigation, but also, from a licensing standpoint, in our business where we license our inventions, with all of this litigation reform out there, companies are sitting on the sideline and saying, maybe we shouldn't do anything right now. Maybe we should wait and see what happens, because maybe that patent that you're trying to license to us won't actually be as valuable as you profess it to be. And we may have, as the licensee, a very difficult time being able to enforce the rights that we are trying to license from you. And so it's just not a good situation right now for inventors. It's not a good situation for companies. It's a great situation for companies that are infringing on intellectual property, because there's uncertainty.
So let me just address that nuance of that, on that, is that, yeah, that is the legal fee, but because of the last American Invents Act changes, we now have to file and file and file and file, because we cannot just be the first to invent anymore. I mean, that's an issue, I know, over water over the dam, but that's really where it ends up costing the small company now more, is that before we were able to be that first to invent. And, you know, there's arguments to say, look, you know, I know that when companies I've invested in, you know, we've said, look, get that patented and get that filed. So, you know, there's issues on both sides of that. But if you're not fully ready to file that patent, the previous changes made it so that you really had to make sure you put your stake, you know, in the ground sooner rather than later.
Let me add, there was also a bill that went through Energy and Commerce at the end of last Congress that most of the small inventor community was behind, and it was a surgical strike at demand letters, and it was specifically geared towards the bad actors. And it's a tight line to walk, because there was other bills that you could have sent a ream of paper as tall as me, and that's scarier than just a generic bad demand letter. But we think that they had done a really good job in that committee working on it and getting it down to something that was workable for a small business.
I wanted to ask a question about a form of intellectual property ownership that Professor Mossoff, you guys alluded to earlier, and that's trade secrets. And I anticipate that maybe this might be an objection from the other side that some of the staffers might encounter. Why would it be, or why isn't it that entrepreneurs and midnight garage inventors can't just rely on trade secrets, which is as I understand it, heavily protected by state law? And why would that disadvantage them and advantage the larger businesses?
I mean, the venture capitalists can probably better answer your question, but I can tell you just from a more general perspective, kind of a big picture perspective, is that because trade secrets have to be kept secret, and the way that you can only get a venture capitalist or a company to invest in your invention is by disclosing it. And so what trade secrecy creates are silos effect for innovation, where people don't trade ideas, don't disclose information, and for the people who do try to do so, it increases their costs heavily, because then you have to have the 30-page non-compete, non-disclosure, covering every possible angle that you could think of to prevent someone who you're potentially entering into a license agreement with to do this. I teach trade secrecy law as well, and I'll tell you, I mean, these are real problems. And one of the purposes of the patent system is and this is another part of the rhetoric that you hear, is that patents don't forestall innovation, because it's all about disclosure, because it's a property right that's fully protected, so you can fully disclose it. And then it's put into a public repository at the patent office, so people know whom to go to, because it's listed who's the first company that's assigned to or licensed to. And people who want to compete with you, they can read that and figure out how to design around it. And so that's how we promote innovation, is that it makes it possible to enter into seamlessly, cheaply, with low transaction costs, the types of funding agreement, licensing agreements that people enter into, especially when you're that sole inventor and you lack the sophistication about how to protect your idea through the non-disclosures and non-competes. You have to rely upon a lawyer to know that my patent gets me that same type of protection without having to have that additional cost imposed upon me. And it's why patents have been the go-to point for most innovation as a result of that. I don't know.
Yeah, I've never invested in a trade secret, so I don't know.
Well, there you go. I mean, that much shorter, clearer point.
Let's take one more question. Our panelists will stay up here after the event.
Yeah, you've spoken quite a bit about property rights and their evisceration, and how important they are. And you've spoken about the fallout from the market outside of the legislative process. What do you have to say about the evisceration of injunctive rights on this whole matter, especially the rising costs of inventors to enforce the patents?
Right. Well, that began the process. I mean, in 2006, the U.S. Supreme Court's decision in eBay v. Merck Exchange, where they made it much harder for patent owners to obtain injunctions, and as it has been applied by lower courts since then, it's become almost impossible to get injunctions if you were in fact license your invention. You don't manufacture, and this impacts significantly the ability for licensing and the valuation of your property rights, because if you can't tell someone you have to stop using my property without my permission. If they know you can't say that to them, their response to you is, so sue me, which imposes more costs upon you, and or they say they're even smarter and they'll say, all right, I'll discount by the cost of your lawsuit that you're not going to get an injunction anyway, what I'm now going to ask for a license rate from you for. So at the end result is you've eviscerated the very value of the property right they were supposed to be securing, which is exactly what injunctions are about. People, this is kind of a misunderstanding of injunctions. People think injunctions is about stopping, and that's entirely false. And in fact, this is what I teach my students when I teach real property as well as patent laws. Injunction is the start of the story, not the end, because injunction is what then forces the infringer or potential licensee to start the negotiation process that they should have started in the first place.
And theoretically, it encourages the bad behavior to begin with, right? So if the other side realizes that you can't stop them without suing, and the cost to sue for an independent inventor is so high, and then out of all the new things that are being thrown in here, like fee shifting and joinder, it makes it that much more difficult for the independent inventor to stop. And so what it creates is this ability for the other side to basically, affect what the outcome is going to be. They can come and do a lowball offer to negotiate because of all the costs and burdens associated for the inventor trying to protect his rights.
Well, on behalf of the Center for the Protection of Intellectual Property, Entrepreneurs for Growth, and the Inventors Project, thank you all for coming. Let's give a hand
Thank
to
you.
Professor Mossoff, Lewis, and Bowers.